Hi, I'm Dan Couvrette, the publisher of Divorce Magazine, and I want to welcome you to this seminar on the Divorce School. I have the pleasure today of speaking with Allison Williams, who is the founder of Williams Law Group. She practices family law with an emphasis on child abuse. Allison is in New Jersey, so if you're listening to this seminar outside of New Jersey, you want to check your own state because there is child protection services in every state. And consult with a family lawyer, ideally a family lawyer like Allison, who focuses her practice and has a considerable amount of knowledge in the area of child abuse and family law. Allison has established herself as a thought leader in the area of child abuse and child welfare law. She is a member of the American Academy of Family Lawyers. That is an organization, the most prestigious organization of family lawyers in the U.S. She is certified by the Supreme Court of New Jersey as a matrimonial law attorney. I can't sing praises enough for Allison. If you go to the internet and look her up, you'll find there's many places that she shows up. She is truly an expert in the field of divorce, children, and abuse, and I'm pleased to have her with me today. Thank you for joining me, Allison.
Dan, thank you so much for having me on today.
So we're going to talk about child abuse allegations from I guess both parents' point of view today. My first question is about when the Division of Child Protection and Permanency becomes involved. What sort of things are they looking for to determine if a child is being abused?
Well, Dan, I should start by saying that in New Jersey, our Child Protective Services Agency is known as the Division of Child Protection and Permanency, also referred to as DCP&P. And every state in the country has its own Child Protective Services Agency. That is a requirement of the federal law, the Adoption and Safe Families Act. So if when I refer to the Division of Child Protection and Permanency, or DCP&P, for the audience, just know that you should consult, even if you just search Child Protective Services on the internet in your state, you should be able to pull up the name of your agency. But in New Jersey, and this is pretty much across the board in all of the states across the country, child abuse is defined not just as the things that we normally think about them. Of course, everyone kind of has those shocking images of the child that has burns or bruises or cuts or things like that on their person, and of course most people would say that child has been abused. But the things that the agency looks for go far beyond the superficial damage to a child that's pretty apparent. They look for not just the outward signs, but also the behavioral changes in children. What are we seeing in the child's behavior that tells us whether or not there's a problem at home? And they look at not just how the child is doing today, but how they're doing relative to the recent past as well as perhaps even the distant past. Are they doing poorly in school relative to how they've done in the past? Are they having medical issues that one would not expect to be there, but for either a dereliction of duty on the part of the parent to really look at what's necessary for the child, or even to go further to say that maybe the parent is harming the child? And of course, they assess the issue of child sexual abuse, which is a very unfortunately common accusation, even though it is very rarely substantiated relative to the other forms of abuse and child neglect. So in New Jersey, we have this broad category. There are 6 different categories of child abuse, and they include some of the things I've talked about. But the broadest category is what we refer to as child neglect, where a parent has failed to exercise the minimum degree of care. And that typically is defined as behavior that is reckless, behavior that goes beyond simply making a mistake, but that a parent knew of a known risk to their child and exposed them to that risk notwithstanding the risk, and that they could have averted it had they done some precautionary act. That is the most commonly pled allegation of child abuse or neglect when the agency goes to court. So that's what we normally look for, and that's the area that most people are a little bit surprised about hearing that behavior constitutes child abuse. So the common example I use is when a parent goes to the grocery store and leaves their child in the backseat of a car to run inside while the child is sleeping. That's a very common behavior. And notwithstanding that, the agency's perspective, given the age of the child, in most circumstances, if the child is of tender years, if you're talking about 5 or younger, and the child was left alone in a vehicle, they're going to say that that was child abuse. Many people have a different view of that and would say that that was not necessarily the best choice, but it isn't, however, child abuse, but, it's arguable based on the broad definition of exercising minimum degree of care. So that's what I usually tell people when they ask me the question, what is child abuse and how does the agency look for it?
Right. Now, if a parent is accused of child abuse and has nothing to hide, should they just submit to an interview to end the agency's involvement?
Well, almost universally, I tell people that they should not submit to an interview, but candidly, it does depend. If there's any allegation that is brought to the agency's attention, they are required to speak to the accused parent. So when the accused parent is contacted by the agency, their first thought is, hey, I've done nothing wrong. Let me just tell you what's going on. The problem is, because of that broad category that we talked about earlier, the minimum degree of care standard, a lot of things that a parent may see as relatively benign behavior could be contorted into an accusation of child abuse and neglect, especially if you're aggregating what the accusation is with other things going on in the home. So, for instance, when the agency comes out and if there's domestic violence in the home or even if there's a lot of arguing in the home, a lot of times parents will be candid about that and say, well, I'm not abusing my child because I have discord in my marital relationship, but yet the child is being exposed to that and may be harmed by it. They may be emotionally suffering because of that. And so a lot of times people will admit to things, being as forthright as they can, thinking that they're helping the agency with their investigation, and ultimately that then causes the agency to have concerns that lead to them requesting evaluations, which often go much further than the parent ever anticipated. So my advice to people in that scenario is always consult with an attorney. And, hopefully it would be a very quick conversation. It doesn't have to be a lengthy consultation, but just say, here's the nature of the allegation that has been presented to me. Here's what my history with the agency is. In New Jersey, it's very, very different from county to county what things will concern the agency. So you need to have somebody on your side that you're speaking to who can really tell you, in this county with this issue, my experience with the agency has been. If your attorney is not telling you those sorts of things and is giving you blanket statements about the law, the application of that may be very different in your area than in the practice area of the attorney. So it's very important that you get good advice about it. But if you have any question whatsoever, when the agency comes out, just tell them, I'm happy to cooperate. They have to see the child when they come out to the home. They have to know that the child is okay. But typically, if they see the child and the child is not manifesting any immediate distress, depending on the nature of the allegation, they typically will work with you on scheduling an appointment in the very short future, but certainly with an attorney present or giving you the opportunity to consult an attorney before your interview.
I want to point out to people listening that Allison is a lawyer and I'm not. I've been in the divorce business for 20 years as a publisher of Divorce Magazine. And I want to underline that it's really important that you do seek help. Many people think that they're assumed guilty if they go out and hire a lawyer, but in this case, I'm sure it's very challenging to deal with the emotional that you'd be going through if you were accused of abusing your children. So I highly recommend, like Allison said, to seek a lawyer, somebody who has experience like Allison, to represent you, because in a situation like child abuse, it's difficult to represent yourself. But Allison, once the agency decides to go to court, what is the best way to defend allegations of child abuse or neglect?
Well, once you get into court with the agency, you always want to read the complaint that they serve you with, and you want to go through every allegation and be very clear as to what's true and what's false. More often than not, people will point out that the agency misrepresented their statements, and sometimes that's willful, and many times it's not. You're recognizing that you have one or two people coming out to your home. They're scribbling down notes of what you're saying. They're trying to capture it all. They're trying to understand. They're observing you and your demeanor. And many times they simply write things down incorrectly. You also want to go through it with your attorney to understand what can and cannot be proven at trial. Because what's most disconcerting about these court actions is that the agency gets to rely upon their records of what they have documented you're saying to them and what every other person has said to them. So someone comes out, interviews you, and then relies upon your interview to use that against you in court. As horrifying as that is to most people, your statements can be used against you in any court proceeding because you're a party to the action. But third-party statements cannot be used against you unless there is an exception to the hearsay rule. So what I tell people is you're going to have hearsay presented to you at all stages of the court proceeding. statements made by third parties that are not under oath, that are not in the court proceeding. And at the stage of trial, that doesn't come in. So if you understand at the outset of the case that what is stated in the complaint is not likely to be proven at trial, you may be able to get the case dismissed even before you get to the point of a trial. You always want to have an expert in these cases. If the state is getting an expert, if you cannot independently afford an expert but you can afford an attorney, you may or may not be eligible for getting assistance through the public defender's office for the purpose of hiring an expert. And finally, I always tell people that if the agency suggests that you engage in certain services, that they think you need counseling or that you need a substance abuse evaluation and perhaps you need treatment, you should always consider getting your own services rather than the agency's. If you submit to the agency services early on, what is provided to these professionals can be used against you. It is shared with the agency. You don't have the level of privacy that is often necessary in order for you to have a truly valuable therapeutic relationship with your treating provider. So in those circumstances, it almost makes the most sense for you to get your own. If you can't get your own, sometimes you can agree to participate in the agency services, but you got to be very careful and try to get as much limitation on the release of that information as possible.
So just so I understand what hearsay is, let's say a husband accuses his wife or soon-to-be ex-wife, if they're getting a divorce, of abusing the child. Is what the husband says to the Division of Child Protection and Permanency, is that considered hearsay, or what is hearsay?
Well, hearsay is an out-of-court statement that is offered to prove the truth of what was stated. So it is technically hearsay any time that a person is trying to rely upon a statement that was made to them by someone outside of the court proceeding, and you're offering that statement for truth. However, for parties to the litigation, meaning the division caseworker is a party, the child is a party, and the parents are parties to the case, in those circumstances there is an exception to the hearsay rule that is allowed, that any party to the action, their statements can be admitted and used against them in the court proceeding. So hearsay in general is not allowed in court proceedings, and it's the same with division cases at the point of trial. The exception, and what makes it a little bit different in a division case, is that you can actually have hearsay at all stages of the proceeding except the trial. Whereas in family court, if you're going to court with your spouse or your former spouse and you're arguing to the judge that you're entitled to certain relief, the court is not entitled to rely upon hearsay. There's a court rule that says that you can only rely upon information that would otherwise be admissible, meaning it complies with the rules of evidence.
So how do non-targeted parents make use of the agency's record process to keep their kids safe?
Well, any time that the division goes to court, they have to name both of the parents as parties, as defendants to the case, because they're seeking relief regarding the child, and the parents both have a right to be heard about that. So what I always tell the non-targeted parent is use that to your advantage. You're being provided a lot of otherwise confidential information about accusations made against your former spouse or your former partner, the other parent of the child. Keep that information and use it for safekeeping in the future. If you and the agency are on the same page that this child has been abused, you can make arguments from the information that they have gathered. You can retain your own expert and have that expert review these reports. If the case is resolved and ultimately the child abuse has been addressed, you at some point are going to go back into family court, if you can't reach an agreement, and argue about what is the appropriate custody and parenting arrangement. And if you don't believe that the concerns have truly been addressed because the agency improvidently believed that the other parent had addressed their concerns, or perhaps they just gave short shrift to the concerns by the child, then you can certainly argue to the court in the family court from the information that you've gathered. You shouldn't step out of the process because you're not the accused parent. You should definitely stay involved, stay in contact with the agency, get as much information as possible, and keep that information handy so that you can protect your child.
So what happens if the agency goes ahead, they do their investigation, and they say there's been no child abuse, but the parent firmly believes that the child has been abused? What can be done?
Well, whenever the agency reaches the allegation, the outcome of the investigation, and they say the allegation is unfounded or not established, meaning they don't find there's child abuse, the parent who believes the child has been abused is really in a precarious position because At that point, you have no remedy with the agency. Your remedy is solely in superior court. In New Jersey, you have the right independently of the agency to file a Title IX complaint, Title IX being the statute that alleges abuse or neglect and identifies how to deal with it. You can file your own complaint, and you can note to the court that the agency's outcome was something that you don't believe is correct, and you can ask the court to conduct its own independent hearing on the issues, because in the family court case, the allegation is really being made by one parent. We'll say it's by the mother against the father. The agency, having investigated it, is really neither here nor there because they're not a party to the divorce case or the family law case. But whenever you're going to court in these circumstances, you want to make sure that the parent understands that there's a lot of hostility that the judiciary usually imposes in these circumstances, because their view is that the agency is entrusted with investigating and dealing with the issue of child abuse. So if the agency investigated and did not find child abuse, who is the judge really to overturn that or look the other way and say that they see something that the agency doesn't? So a lot of times judges want to close the book and say, look, the agency's ruled, I'm done. However, what you should always be cognizant of is that in about a quarter of the cases that get up to the appellate division where the agency has made some type of finding, those cases are overturned on appeal. So that's about 1 in 4 cases. And you always want to say to the court, do you want to be that judge who threw out a claim of child abuse, God forbid what it is, that this child was sexually abused or physically abused or emotionally harmed by their parent? Do you want to be that 1 in 4 that got it wrong simply because you looked the other way? And we have case law in New Jersey that actually says judges are not allowed to abdicate their responsibility to make independent findings of facts and conclusions of law on the facts that are before them simply because there is someone else who has reached a conclusion. You can't abdicate to an expert, a guardian ad litem, and we even have a case that says you can't abdicate to DCP&P or the Child Abuse Agency.
I'm sure a strong and experienced advocate like yourself wouldn't hesitate to remind them of that fact if you're representing a client in court, right?
Yeah, well, much to their chagrin, that's true.
So how does a parent gain access, or can they gain access to the agency's records to try and prove that the child has been abused or neglected?
Well, CPS, or Child Protective Services agencies, are confidential. And again, that is by federal statute, so that is the case in every state across the country. Because the records are confidential, typically you're not entitled to whole-scale access to them. However, in New Jersey, there is an exception to that. In most states there is, to the confidentiality. In New Jersey, what you have to do is you have to plead that before the court, you have to say there's an issue before the court to which these records may be relevant. And you just have to state it generally. Once the court has something that may be relevant in those records or identifies something that may be relevant, the court will order the agency to produce its file to the court, solely to the court, for what's referred to as an in-camera review. So the judge will review the file in his chambers, his or her chambers. Once the review is done, then the court has to tell everyone generally what is there so that the attorneys can make arguments under a case in New Jersey known as State versus Cusick, a Supreme Court case that says effectively that these records are confidential, but they can be released by the court in circumstances where the records are material and relevant to an issue before the court. They are not available from any other source, and they're likely to impact the outcome of the case. So normally things such as psychological evaluations, investigation reports, things like that are generated that have already been created by the agency that would be somewhat different if they were created by another professional who didn't have access to the agency's records, those are almost invariably likely to be released if there's a custody, parenting time, or child abuse allegation before the court. But the court has to tell you generally what's there, and then you can make your arguments. And different judges view it differently, but usually some form of limited release will be allowed, if only to have the attorneys come back into chambers and take a look.
What happens in a case if the judge suspends access or doesn't allow the accused parent to see the child pending the agency investigation, and the investigation comes back and says, well, there was no child abuse? Is that time somehow restored at the end, or what can be done to rectify that situation?
Well, normally this is a very common scenario that we see, that one parent goes into court, files an emergent application called an order to show cause in our state, and says to the court, the agency is investigating, so therefore there shouldn't be contact between perpetrator or accused perpetrator and child. Court suspends access, and then once the investigation is over, there is no longer the same basis under the previous court order to suspend access, because the court has previously ruled on suspending access pending the investigation. However, once the investigation is over, you still are before the court to address the issue of child safety, and that is always the court's paramount concern under both our custody statute as well as the child abuse statute. Under the court's authority, we refer to it as parens patriae authority. So the court has the responsibility to protect the child anytime an order is being sought. At the point where the investigation is over, the parent who believes the child has been abused should make every argument available that the investigation was not complete, or that it was botched, or that there's information that's in their reports that the court should consider before allowing access with the accused parent. And that could be anything from psychological evaluations to even merely disclosures that the child made. I've been involved in cases where the judge was aghast to learn that the child actually made disclosures of having been touched inappropriately by their parent, and the agency simply dismissed or did not find those statements credible. And the court said, well, what was done about these disclosures? And the agency's view was, well, the child's so young, we'll never be able to prove it. And the court was very dissatisfied with that finding. And as a result, the court required that there be further evaluations and continued the suspended access. So you have an argument regardless. You just have to know that you have to be ready to go as soon as you're told by the agency they're about to close out their investigation with no finding. Be ready to go to court and make your arguments.
So what happens at the end of the day, Allison, if somebody's gone through the Division of Child Protection and Permanency, they've gone through the court system, and no signs of abuse have been found? What do they do if, to protect their children, and they still believe that their child is at risk?
Well, there are a lot of options that are available if the court process fails. What I always ask people to consider is how long the child has been out of the care of their other parent. If a child is very young when they make an allegation of child abuse against their parent, they may or may not be distressed by the things that they are disclosing, because not all child abuse is traumatic, particularly in the form of sexual abuse. So you can have a child exposed to inappropriate touching or inappropriate gestures or watching pornographic materials, and they don't understand that they have been harmed. Or if they understand it, they are, at the point in of their maturity where they're ready to forgive and move forward, and that's not always appropriate for them. So you have to think about it from the perspective of how is the child going to experience a relationship with the other parent. Sometimes we deal with that by having the child engage in reunification therapy between their estranged perpetrator parent and the child, so that a professional can observe and interact with the child and the parent, understand what the child's experience is of that parent, and decide whether or not it would be safe in the emotional well-being of the child to release the child over to the parent. If that type of service can't be instituted because the court doesn't agree with it, many times what parents have to do is really some of their own self-monitoring. And it's difficult because after you've gone through a long process, any new allegation that comes up or any new concern is often viewed as sour grapes on the part of the parent who believes that the child was wrongfully found not to have been abused the first go-round. But that doesn't mean that you don't make the allegation and that you don't raise the concern. If the child is seeing a therapist, that's another good way of advocating. I always tell parents, if you think that your child has been harmed but you don't think that you will be believed, then you want to raise those concerns with a treating mental health professional, and that professional can raise any type of concerns that they feel are warranted with the agency. Sometimes just getting the therapist to make repeated referrals to the agency can keep a period of time where the other accused parent is being supervised in place, because the child is expressing things, even if they're not true, the child is experiencing distress around their relationship with the accused parent. So there are ways of keeping a distance, a safe distance between the accused and the child, even though the court process did not result in a finding of child abuse.
Allison, I want to thank you for your time today. For those people who are listening, I recommend that you visit Allison's website. There's a great deal of information and resources that are available on her website. You can simply do a Google search of Allison Williams, family lawyer, New Jersey. It'll come up, and many things will come up, her website and many other items, or go to her website. The address is New Jersey, DYF as in Frank, S as in Sam, defense.com. You can also listen to another session that Alice and I did on children and divorce, where she talks about parenting plans and helping children through their divorce. And please check out our other divorce school sessions while you're on the website. Thank you again, Allison, for your time, and thank you, folks, for listening.
Thank you, Dan.